Hello, everyone. Welcome to this AALS webinar, Teaching Administrative Law in a Transformative Era. For those of you who don't know me, I'm Christine Chabot, and so glad you could join us today. Just some quick thanks before we introduce the members of our panel. I wanted to thank my section chair, Glenn Staszewski, for his help setting up this event, and also he's going to help with the Q&A queue later at the end of the panel. Also to Shannon Leonard and her team at AALS for all of the tech support. And last but not least, so glad to have all of our panelists with us today. We have a very distinguished, knowledgeable group of administrative law scholars who are going to walk us through some questions that I'm sure many of you have about how to restructure or change your administrative law classes in light of the recent Supreme Court decisions that we've had in this area. And just a quick note, unfortunately, one of our panelists, Jordan Paradise, had to drop out at the last minute for understandable family reasons, but we are delighted to have the rest of our group with us, and I'll run through really quickly. We have, again, a number of real experts in the field, starting with Hal Krent from Chicago, Kent. Then we have Sabeel Rahman from Cornell, Kate Shaw from Penn Law, and last but not least, Dan Walters from Texas A&M. And with that, I'll just get started. I'm going to give the whole panel some questions to answer with their reactions on how they're going to reshape or craft their classes in response to some of these issues we're all thinking about. And then at the very end of this kind of Q&A session, Glenn is going to monitor the chat for questions that you as a member of the audience may have. So feel free to put those questions into the chat, and we'll try to reserve some time at the end to make sure audience questions can be considered as well. So for starters, everyone in this field has been talking about the Supreme Court's recent decision to do away with Chevron deference and its new decision in Loper Bright. So a big question then for professors is, how do you plan to change your administrative law or leg-reg course in response to Loper Bright? And here I'll just walk through the panelists and ask each one to give some reactions on how they think their course will change in this fashion. And we can just go with our starting order, beginning with Hal Krent.
So I'm sure that my response will be similar to many others. There's no need probably to go into great depth about talking about the Meade case, doctrine, and so forth, or talking about the question of whether or not a court can second guess when there's been a prior court's decision upholding a judicial interpretation. But I want to do something that's maybe a little different because I'm counter-cyclical that way, which is I want to say something that I plan on continuing to teach. I may have been alone, but what I used to teach before Chevron was what I call the world before Chevron. And I characterize it as a kind of canons of deference. And there are competing canons, and there's all sorts of problems. So just briefly, I don't want to spend too much time. I talked about Gray versus Powell, greater deference when Congress implicitly delegates, NLRB versus Hearst, greater deference when there's a mixed question of law and fact, Ford Motor Company versus Mulholland, greater deference when the agency helped shape the statute, Norwegian nitrogen, greater deference when agencies' interpretation is contemporaneous, and NLRB versus Bell Aerospace, greater deference when there's a long-standing agency interpretation. I would go back and forth with the class about why there's more deference in these contexts, and then talk about the role of the burden on the attorney to sort of look through all these different kinds of canons of deference and come up with 4 on one side, 2 on the other side, and then try to present it to the court. And the problems that existed pre-Chevron, which was it's unpredictable. Some kinds of judges liked some kinds of deference, some liked other kinds of deference. And so what the beauty of Chevron was it tried to create a structure, a unification where none existed previously. What's my point? The point is that Loper actually cited 3 of those decisions as to what should guide the court in the future. So they basically talked about what are some reasons to defer to agencies and care about what agencies say in their interpretations. So I think we are headed back into, at least in the interim, into a period that existed prior to Chevron, where there are different judges, where there are different kinds of theories of why special deference will be due given all these different kinds of contexts. And so we're going to go back into the situation that existed before. So I think it works really well to set up Chevron as a response to this sort of semi-lawless type of dueling cannons, and then because that may be what's coming next. So just wanted to put that out there.
All right, thank you so much, Hal. And next we'll turn to Sabeel for your view on how you might incorporate Loper Bright, or what preceded it, I guess.
Yeah, great. Thanks, Christine and Glenn. And that was really helpful to hear how I should say, I think I am also eager to learn from co-panelists, and good to see many friends and colleagues on the Zoom as well. So maybe just to zoom out for a second, I think for one of the interests I have is in trying to teach administrative law as a way that we collectively try to grapple with how we solve public and social problems, both in the formation of agencies in the first place, like why do we have an FTC? Why do we have an EPA? But then in the sort of battles over what the scope and application of their authorities, then how those play out. And so I say that to say, I'm really interested in kind of framing that for students as both sort of, there's an internal conversation, sort of how do we make sense of the doctrine and how do you maneuver in it as an advocate? I think a lot of Hal's ideas are really great there. And I've been spending time, as others have, sort of going back and spending more time with, Skidmore and all the many implicit and explicit factors in Skidmore, for example. So I think there's an internal doctrinal piece to that. But I'm also interested in putting Loper in a larger sort of unit that I'm thinking about, that is about like the fight over agency power as a kind of proxy fight over what do we want to do about economic inequality or about racial and gender injustice. And so I'd want to actually put the Chevron Loper Bright sort of current conundrum in the same unit as major questions doctrine, which I'm sure we'll get to, sort of the original kind of early non-delegation rise and fall and maybe return, to sort of paint this picture that we're really in a continuation of an ongoing kind of deep philosophical and normative battle over what kinds of state powers do we actually want to see and for what reason.
All right, thank you so much. Next, Kate Shaw, what are your views on how to incorporate Loper Bright?
Great. Yeah, thanks. And those were both really, really helpful presentations. And like Sabeel, I am happy to talk and shed whatever light I can on how I plan to approach this, but also I'm like really selfishly happy to hear from all of these smart scholars who've thought about it as well, because we're all, I think, in the kind of finishing our syllabus moment. So this is like a crucial actually time to get all this really useful input. I mean, I have also follow-up questions about like how the problem is, of course, like we are all already, or at least I already feel as though I don't have nearly enough time to cover the things that came before. I feel like the last, 5 years, the beginning of the semester in administrative law, I have issued a caution about just how much churn there is in the doctrine. And so I do think that, to Sabeel's point, like providing the kind of conceptual tools and frameworks is really critical and much more important than like really like instilling the nuances of particular doctrine, because so much of it is so unstable. And that is, I almost feel like the boy who cried wolf, because I've been saying that for years, but it is so true this in terms of this term. So I think so anyway, I totally agree with the both importance of continuing not to jettison everything that came before Chevron. What I'm struggling with is how to make the space for it. So certainly Hearst and Skidmore, I'll continue to teach. Other cases, I would really have to squint at the syllabus to try to figure out a way to include. But I also plan to teach Chevron as well. I mean, I still teach Roe in constitutional law, even post-Dobbs. I plan to still teach Chevron along with Loper Bright, although I will probably condense it, and certainly, Mead and Brand X, right, cases about, right, how actually to implement Chevron, I don't see any need to continue to teach those two cases. What I don't know is whether, to Sabeel's point, to teach Loper Bright together with major questions and non-delegation. At the moment, I've got non-delegation and major questions, and Chevron, kind of far weeks away in the syllabus. But there are all of these, I feel like, circularity problems, and however you sequence administrative law, I don't think there's an answer. I've tried it lots of different ways, and I always end up thinking like, maybe I should have done that a bit differently. But so those are my initial thoughts.
Thank you. And Dan Walters, please add your views.
Yeah, so I think I probably have the least teaching experience of anybody on the panel. And so I was sort of just trying to get my sea legs for teaching generally, and then all of this happens. So it's really been throwing me for a loop. But I'll try to provide some helpful thoughts about teaching in a post-Loper Bright era. First observation I would have is I think it's a helpful reset. Too many students told me that they believed that administrative law was all about Chevron, which is a false impression. I think that made them more likely to underappreciate all of the other aspects of administrative law that we all know are just as interesting and important. So to me, I always taught Chevron for a class or two at most in a semester. I know some people spend more time on it or spent more time on it. I think this is a moment to kind of scale it back actually and talk about a lot of other things that are happening in administrative law and to emphasize to students that there's more to it than Chevron and deference. I think it's also a challenge to teach in this moment. Not every student that we're going to have in our administrative law classes will have taken a class on legislation or statutory interpretation. So the court's independent judgment standard in Loper Bright, I think, is going to necessitate at least a primer on statutory interpretation to the extent that we weren't doing that in administrative law classes before and relying on legislation or statutory interpretation courses to provide that background knowledge. I mean, this is really the game going forward. So we need to, I think, cover some of that basic information in an administrative law class. Substantively, I'm making a few changes that I'll just kind of tick off. One is very in keeping with what we've heard from other panelists. I'm going to do more with case law at the time of the APA's passage. So talking about cases like Gray versus Powell, NLRB versus Hearst, and of course Skidmore. I think the central analytical move that the court makes in Loper Bright is to say that the APA bars deference. And this is both a debatable claim and a teachable moment about the different ways that we might confront ambiguities in the APA, both here and across the canon in other doctrinal spaces. I'm also going to do more on what makes an explicit delegation. Admittedly, this is the million-dollar question coming out of Loper Bright, and I don't think any of us really has the answer just yet about what makes an explicit delegation. But whether Loper Bright ends up changing anything probably depends, at least in part, on how many cases that used to be Chevron Step 2 cases get treated as explicit delegation cases. So some thoughts about how I might structure that discussion. I think it makes sense to think about it maybe a drafting exercise. Like, how would you, if you were a legislator, indicate that you wanted an agency to have discretion, that you wanted to explicitly delegate power to an agency? What language would you use? You could maybe set up some kind of drafting exercise and then, break that down, maybe with like a green team, red team framework, where you would have courts kind of try to pick that apart and say why they don't think that's an explicit delegation. I think it could be a pretty constructive way to get on this or get some traction on this topic. I think also introducing the idea of drafting conventions and legislative capacity to coordinate around the courts. And on that note, I don't know if Bo Bauman is on the call, but he has a brand new Yale Law Journal piece that is on that topic that might be a great framing for that discussion. Finally, I'll be watching like a hawk for a good case to add to the curriculum that demonstrates that Loper Bright might actually be a double-edged sword, and that it might not be the undiluted win that many anti-regulatory voices who advocated for it believe it to be. I think at some point we're going to see some court that's willing to write a really compelling opinion forcing an agency to regulate more because a statute arguably requires it. And when that opinion comes down, it'll be proof positive that it's at least possible to turn Loper Bright in favor of regulation. And I think that would be a really important lesson for students to have coming out of administrative law, kind of the ways that they can use this changed landscape to their clients' advantage going forward.
All right, thank you so much. Those are all great points and things I was having questions about and thinking about. And Dan's last point in particular reminded me that, Chevron itself was originally championed by the deregulatory Reg Ed administration, and now there's been a big sea change. So that's maybe another just interesting angle to think about this in context as well. Does anyone have, in response to the other panelists, would anyone like to jump in with any additional thoughts? This is a really rich area, and I think something that I personally am glad that that section of my legislation course is later in the semester this year, so I have time to process some of these thoughts. But anyone else want to add anything?
Maybe I'll just jump in response to Dan, the first thing you said about statutory interpretation. Yeah, I've always spent one full class on statutory interpretation in administrative law, because, I do think that maybe in schools where a 1L, a leg reg requirement exists, that's not necessary, but where we don't have those, I just think you need some of the basic tools and frameworks of statutory interpretation. And I'm going to do at least 1.5 classes, and I might even do 2. 2, I'm not sure I can justify, but I'm going to beef it up a little bit. It's already a lot crammed into one class, so I don't think I can put any more substantive material there, but, some, basic tools and frameworks, basic, quick and dirty overview of the key canons, a lot of slides. I think that all of that just to provide the truly uninitiated with the basic kind of grammar and vocabulary of statutory interpretation is something that we definitely all need to do if we haven't already, and those of us who do might need to do more.
I have 2 comments as well. I mean, I think Dan's suggestion of this class exercise of trying to draft and then trying to interpret it the other side or to attack it, it'd be great. I don't know if I've never done it, so some trepidation, but I think it's really exciting. But I just feel bad that I taught administrative law over the summer and not this semester because I'd love to try it. So that's sort of one reaction. The other one, and I may disagree with you on this, I just don't think that this is a major case in that sense. I don't think Chevron's as big a deal as everybody makes it to be. I'm of the old school that thinks that, courts kind of do what they can. Maybe this pushes them at the margin a little bit. And if it's a salient case, if they care about it, they're going to decide it, find one ground or another ground to use it. They can call major questions. They can call step 1, call step 0, it doesn't matter because they're going to decide to whether they agree or disagree with the agency. So just the way Chevron only pushed the bubble in terms of that we know about 5-10 percentage points in terms of the win rate for agencies, I don't think Loper Bright, both for reasons you discussed, Dan and others, is going to change that much. So I think the real changes that you adverted to, Sabila, are by Jarkesy has much more of a major chance of changing the landscape, I think, than Chevron does. So I don't think I'll give it. I think I'll give it less, not more, but at the most probably less kind of structure than I did before, because a lot of those chipping away, Brand X, et cetera, Mead is not as important as it used to be either.
One question I had, if I can just jump in, is kind of thinking about connecting these questions about statutory interpretation to what, Hal, you said at the outset, like we're going back to a world before Chevron, but the world before Chevron was not the textualist world that we live in today. So I'm wondering how the Supreme Court's shift to textualism might change the way they go about recreating a world before Chevron or something like that.
Yeah, I mean, and this to me, I thought about this, and somebody else alluded to major questions doctrine before, because the major questions doctrine can be seen as a tool of statutory construction, a new tool that you glob on to textualism, or it can be seen as some other kind of normative canon. And how we look at that now in terms of both non-delegation doctrine and Chevron, I think depend upon what we think of it. I think that I don't think textualism works so well in most of these kinds of agency contexts. I mean, maybe I differ in the kind of stuff that I've looked at in depth. They're so open-ended, right? So many delegations, the FTC, FCC, and all the alphabet agencies talk about reasonableness, talk about, to the extent possible, public interest, and so forth. And so there's just ambiguities legion. So even with the textualist sunglasses on, I think there's still tons of room for disagreement. And that's why it's important to have an agency interpose their sort of expert view of what these open-ended terms mean. The real answer is that if Congress is more specific, none of this would mean anything. But good luck, right? And so I think we're going to left with this kind of ambiguity. And I don't think a textualist world is really going to solve the ambiguities. And so then it's going to be up to judges' political preferences, or if judges don't care, I think they're going to find reasons to say, take a shortcut and just rule with the agency.
All right, well, all great thoughts on how to kind of adjust the syllabus, or maybe not adjust so much, or kind of reiterate what was already there in terms of deference doctrine. I'll move on now to another major separation of powers case that was decided last term. That's SEC versus Jarkesy. And This case actually came from the Fifth Circuit, where the administrative adjudication was challenged on 3 different separation of powers grounds. And as you know, the court ruled on only one of those grounds, finding that the particular adjudication internal to an agency in that case was something that violated the 7th Amendment. So curious to hear your thoughts on how you might respond to this case in your administrative law course. And just to mix up the order, I'll go in reverse order this time. Dan Walters, if you don't mind starting off.
Sure, yeah. Well, I guess I'll start off by just saying I think this case is going to be pretty difficult to teach. I don't know that many of us taught the 7th Amendment before in administrative law. Maybe it came up very briefly with Atlas Roofing, but it certainly was not a mainstay in many of the case books. So obviously that's a new wrinkle here. A lot of the import of the case is for the public rights, private rights distinction in the context of delegation of judicial functions to agencies, which is very relevant and core to administrative law, but it's one step removed. But all of this makes it pretty complicated. It's kind of like an analysis within an analysis, and I don't think it's going to be very easy to disentangle the unique aspects of 7th Amendment jurisprudence from more general questions that the opinion raises about agency adjudication. And for precisely this reason, I actually toyed with not teaching the case in depth this year. And at the end of the day, I did put it in the syllabus. Partly because the holding itself is obviously very important. Despite what Chief Justice Roberts says, the court genuinely made new law here. And the public rights concept, I think, has been significantly narrowed. The fallout from that change could be pretty big, depending on how far the court takes the analogy from modern day regulatory adjudication schemes to common law actions, or it could be a big nothing burger limited to fraud-like claims in Jarkesy. I don't think we really know at this point. But that is a big enough kind of doctrinal change that I felt pretty compelled to actually teach it despite the complications. But I just would underscore that I think we're going to have to do a lot of work to explain how Jarkesy scrambles the already really messy line of cases running from Northern Pipeline to Shore to Stern to oil states to now. And I think for some administrative law professors, the juice really might not be worth the squeeze here. I think you could imagine teaching this line of cases at a more general level, and then just making a note of Jarkesy in class rather than really diving into the really complicated issues in the opinion itself. Another challenge with this case is that it's really hard to ignore the parts of the Fifth Circuit's opinion that the court itself just ignored. So as Christine mentioned, when the case came up to the Supreme Court, a lot of us expected that the court would resolve the case on the removal argument rather than the 7th Amendment argument, and that the court might at least say a little bit about this novel non-delegation theory that came out of the Fifth Circuit. But the court really took a different path and just kind of ignored those issues. And I think there are probably some important points to be explored in all of that. So first of all, why did the court not take those pathways? Why did it not say anything about these other challenges? And what does it tell us about what the court will do in future challenges coming down the pike, such as a case presenting the option of overturning Humphrey's executor? I think it could be valuable for students to use this case to learn that litigants and judges are approaching the entire area of administrative law as repeat players. Their strategy behind each and every decision, including those that seemingly take us back from the brink, as you might frame this case as doing. And so this case, I think, could be a really useful vessel for exploring some of those themes about how doctrine is changing iteratively over time, and how there's kind of a method to the madness.
Thank you. Kate, what would you add to this?
Yeah, that was all really helpful. I do plan to teach it in, I'll confess that I devote less time to adjudication than to rulemaking. I think that's largely, although not universally true. Adjudication super important. I don't find it as interesting and fun to talk about, but I should probably spend more time talking about it, and I will at least have to add Jarkesy to the adjudication portion. I mean, I do think that, I mean, the court said nothing, as Dan noted, about the non-delegation and removal issues, which I think seems to mean those parts of the holding are, you know, at least the district courts in the Fifth Circuit, like, I think could well be ignoring binding circuit precedent if they don't apply those parts of the Fifth Circuit opinion. And so that matters a lot. So I do think that, you know, in the kind of modern, you know, I do a little bit of non-delegation history and then really, you know, just the opinions in Gundy. And I haven't really gotten, apart from, I've occasionally taught like a state delegation case, like during COVID, I did a couple of those early COVID years. So I might add a bit. I was certainly going to talk about it, but maybe I'll even have them read part of the Fifth Circuit's non-delegation opinion, just because something more current than Gundy, I think, would actually be useful for them to see. Because they're sort of like, and then what happened? Where are we now? I mean, one big answer is all of that energy was diverted into the major questions doctrine, and that is largely the answer. But I do think that another non-delegation discussion of some sort might be useful to include. And so anyway, I wouldn't want to spend a ton of time doing it, but I might do that. And certainly, I mean, the removal issue is hugely important. I do, you know, in like a little bit of kind of the, you know, place of agencies and sort of the constitutional order, you know, agencies in Congress, agency and the president. And I talk a bit about appointment and removal, and then assign the Schedule F executive order and a little bit of secondary literature on that. So sort of questions about appointment, removal, you know, civil service, ALJ, like, you know, so I can't remember now. I've sort of, it is expanded and contracted just how many of, you know, the kind of non-sale of law, like in the removal line, which of the other cases I've taught, and I've sort of been playing with that a little bit as I do these revisions. But I think that at least talking about that aspect of the Fifth Circuit opinion would be important, even if I don't assign any of it, as I expect that I won't. And as to where, like, I mean, I don't exactly know, because there also is the line of Northern Pipeline and Shore and Oil States cases. If you are just going to mention those cases but not assign them, you know, which is, I like, there are some notes, but I don't actually assign any of those. I think right now I'm just going to put it after, you know, the constitutional due process material. So as you know, now we have due process questions, and we have the Seventh Amendment question, which also obviously has due process dimensions. And so I think that is where it lives on my syllabus right now, but I'm not sure that, I think that probably is the place that makes most sense. But so that's where I am on Jarkesy.
Thank you. Sabeel?
Yeah, this is great, because as I'm hearing Bren's talk, I'm revising my own thinking in real time. But so a couple of things I would add. I think one, I totally agree with where Kate left off, that I think Jarkesy sort of touches on a number of these issues. So it might well appear maybe in smaller slices multiple times. I do generally spend a class on sort of Crowell v. Benson through Shore kind of line on Article 3, and that's where originally I was planning to bring it up. But I've also been increasingly thinking that in lieu of an adjudication section, to do a part of the syllabus that maybe spend a week, a couple classes on the different kinds of enforcement powers agencies have and the stakes of them having those powers in the first place. So, you know, inspection capacity, disclosure regimes, you know, so the civil penalties piece, you know, it's not a huge deal for the SEC in this sense, but it might be a potentially huge deal for other agencies in being able to actually do the thing they want to do. So I think I'm inclined to kind of have a broader discussion, I think, later in the syllabus about just enforcement powers more generally. I should say, by the way, that in that piece, I think it's also useful to put Jarkesy and the SEC fight in context of sort of ongoing, basically blank check, in my view, deference to enforcement powers when it comes to surveillance and immigration and the carceral apparatus. And I think it's actually important to put those in the same frame, even though that's not always done in admin law contexts. And then I think the last thing I would add here, this is partly going back to our Loper Bright discussion, but it applies here too. In previous years, I've saved the last month of the class to sort of, I kind of blast through the doctrine as quickly as I can. And then I save the last month of the class to do case study deeper dives, where then we can trace a fight through multiple cases. So net neutrality is a good example. You know, a number of the EPA things are a good example. And I'm toying with doing that again this year, because I think it might be helpful to sort of present to this point that Kate raised about the ground shifting beneath our feet and sort of the circularity problem, I think it might be helpful to give students a way to revisit all the doctrinal questions, but see them kind of applying where they're all on the table. And, as an advocate or as an agency general counsel, you're going to have to have in your mind queued up all of these different potential lines of attack or limitations on the agency's ability to operate. At the same time, life will not present itself in the neat doctrinal categories. So I think this is another one of those where a big picture overview at the end of the class, maybe using some of Dan's ideas about sort of red team, green teaming might be useful.
So I'll jump in. I have a slightly different idea, and I did get to teach it as it was coming down the summer to my students. And maybe unlike you, I don't go into the Marathon case or oil states or Shore. I mean, I lectured a little bit about it. But where I thought Jarkesy came in helpful is after the early stages talking about how is adjudication for agencies different than in courts. And there is a lot of early cases that are in most of our case books that talk a little bit about the fights, about what kind of, do you need cross-examination? Do you need discovery? Do you need, what's the status of the ALJ versus the judge? All those different issues. And I think Jarkesy is helpful after that because it shows that the people who lost those early fights in terms of what agency adjudication can look like have sort of gotten a little bit the revenge in saying that there is something different qualitatively about adjudication. And so those now that are in power are able to say we have a strong preference for traditional court adjudication. And there really is something distinct, and there is something distinct about adjudication before agencies, even though I defend it. And I think, therefore, it's helpful to show that kind of linearity, and I think the students pick that up.
Let me, Christine, if you don't mind, there was a question in the chat that I feel like just fits in really well with the conversation. It's how does good old Crowell versus Benson fit with Jarkesy? Sabeel, you mentioned teaching Crowell, so you might want to take this.
Yeah, quickly. So I plan to keep that line sort of Crowell through Shore and put Jarkesy in there, but this conversation makes me think that Jarkesy also might appear a second time or a third time over the course of the syllabus, perhaps briefly.
Anyone else have thoughts on that before we move on? Okay, great.
All right, and I would just add to Sabeel's point about the idea of showing the students how multiple doctrines may come up in any different challenge to an agency. I think that's especially relevant these days. And one of the other big administrative law decisions that I don't know that people necessarily add to their course, but the challenge to the Consumer Financial Protection Bureau's funding, that was an argument buried in the end of the briefs on top of a lot of these other separation of powers challenges. And the court kind of plucked it out and said, yes, I think there's a violation here. So this idea in separation of powers litigation and Jarkesy itself, right, where we have these three separation of powers questions, and people thought maybe it would be the Article 2 removal question, and then no, the court switched to the Seventh Amendment as its main target. That's probably a valuable lesson for students too, and maybe something that's a little more challenging to fit in the way most of us teach our courses, because I think we do usually break it into different doctrinal buckets normally, right? But maybe some way to tell students, make sure you have all these in play at once, right? And recognize that there could be, it's not enough just to think about the main argument. Perhaps people are considering there could be more avenues of attack that might be coming, and either raise those if you're on one side, or consider how to defend against them if you're arguing for the other side. And if there are no more thoughts on that, I'll just turn.
I'll have one brief.
Sure.
I don't think Jarkesy is a great case for the non-delegation doctrine because it's such a narrow question, and it's almost specious to think it's a non-delegation problem. But just to add on to what Kate was saying, there are really interesting courts of appeals decisions now that raise non-delegation about, universal service fee for the FCC, or, about the OSHA and about other kinds of issues. So you can easily scrape some of these that are more contestable, that show some of the important issues that come with non-delegation. And I don't think Jarkesy is a great case for that.
All right, thank you. If there's no more, I will move to a next question, which is we're probably even just scratching the surface to say that Loper Bright and Jarkesy are the only new cases we might want to consider as administrative law professors. There have been a lot of important cases over the last few years, and I think likely there will also be another challenge to Humphrey's executor coming soon. Many are predicting. So was just curious to get different takes from the panelists on, are there other recent cases or, themes of the court's decision-making that you are going to emphasize in your classes? And maybe I'll go ahead and start with Kate for this one.
Sure. Well, just sticking with the most recent term, maybe I'm alone, but I do feel like Ohio versus EPA needs to be included. I mean, I'm also struggling with, Sabeel was saying, well, sometimes some of these cases seem like they need to appear at a few different places. I both on the kind of big arbitrary and capricious discussion, but also on kind of the notice and comment process, obligation to respond to the public. Feels like you kind of have to teach this, sort of weird one-off, but like really important decision in both of those places. And so my instinct right now is definitely to include it, and possibly to include at least a discussion of it, maybe read it once and revisit it the other time, because the kind of obligation to respond, the sort of the nuts and bolts notice and kind of comment process cases tend to be Court of Appeals cases, and some of them are sort of weird and not super satisfying. So I actually think it is kind of helpful. I mean, I think it is actually specious, but there's at least a discussion that is, that one can follow about what the EPA did and did not sufficiently, in the majority's view, do here. And so I think that is one from the most recent term that I do think I have to find space for at least one and possibly two appearances. And then Humphrey's executor, yes. I mean, yes, we obviously teach all of us, I think, some versions I was saying before of appointment and removal, and whether, there's a pending case that just had an on-bank petition denied in the Fifth Circuit, like, is it one of the pending cases, or is it just like a broader set of conversations that we have been having, presumably in some form in these classes for years, but where, the kind of intensity is ratcheted up because it is quite clear that there will be an existential challenge. You cannot sort of chip away at the periphery of it and sort of leave it standing for much longer, if any longer. And there's nothing on the docket right now, I don't think, that actually puts that question to the court directly. But it seems to me like a 1 to 3 year kind of proposition. And so how to tee that up to the students, I'm not quite sure that I know how to do. So I'd be curious for others' thoughts, but certainly we need to talk about what we think about the future of Humphrey's executor.
Sabeel?
Yeah, I totally agree on Ohio v. EPA and on the funding cases as well. Even the the CFPB challenge that didn't quite hit all the way, because I think that'll keep coming up. I think in terms of themes, Christine, this has come up a little bit already, but I do think it's really important, and I plan to do this in my con law class as well, to just be really upfront with what I think is really going on here, not just a bigger sort of ground shifting on the doctrine, but there's a specific political, ideological, normative, however you want to characterize it, point of view that is being prosecuted, that is also being prosecuted, in context of a broader sort of congressional incapacity, sort of to Dan's earlier point, also in context of a broader sort of electoral, kind of structural electoral problems that, why is the 6-3 court in this particular formation that may or may not sort of align with what at best is a 48-48, public view on some of these questions. So, I mean, that's more of a thematic point, but I think it relates to all of these doctrinal areas in admin law, because I really want to convey to the students that the stakes of these often technical, really in the weeds, procedural, cases is really about what powers the state has to do things for people. And I don't think it's a coincidence that a lot of these constraints on agency authority of late are particularly hitting against, policies that are tackling different kinds of inequity of various kinds, or the climate crisis. And so I just say that as a broader thematic that I want to try to weave through from the beginning all the way through the course.
Thank you. Hal?
So I taught Axon last summer, and I taught it, doctrinally, because I think it's a change in doctrine, a surprising change from implicit preclusion. But I wanted to get at two other aspects of it I thought it was helpful for students to know. First is the idea that they're familiar with the least most of them are, with the final order doctrine in general litigation. And just looking and comparing to the Ministry of Law, it's just so different, right? You can appeal and get appeal even beforehand in terms of administrative law now. And it's surprising, again, carrying on with other themes that we've talked about, that the court is treating the two contexts so differently. Indeed, in district court, you cannot appeal an appointment to an arbitrator, an appointment of a master, even on constitutional grounds. That's not immediately appealable, but it is here under Axon. The second part is I want to sort of probe the court's assumption, which I think is absolutely wrong, that administrative agencies don't deal with constitutional issues. I mean, not only do they deal with constitutional issues all the time, which I think is important to impress upon students, despite what the court suggests, but indeed, agencies have in the past and can respond to structural claims, including in the appointment and removal. Agencies can just take away cases from ALJs, and they have. So the thought that agencies can respond to structural questions is both, historically inaccurate, and I think is misleading. So I think it's helpful then to use that not only, again, doctrinally, but to explore other aspects of the court's role in this context.
Thank you. And Dan?
Yeah, so I would agree with what Kate said about Ohio versus EPA. I think that's absolutely essential to put in the curriculum somewhere. Again, another pretty complicated case, and it's, there are reasonable disputes that you could have about where the most appropriate place to put it in the syllabus would be, but I think it's an important development. So I guess I want to focus a little bit more on thematic framings that we might use going forward. I've already hinted at this, but I think a big theme to start emphasizing a lot in administrative law is interpretive methodology when it comes to the APA. For me, at least, Loper Bright was a wake-up call that originalism and textualism are coming to the APA, whether we're ready for it or not. And I think it's imperative for us to start to tease out what that might mean for administrative law across the board. So not just Loper Bright, but also rulemaking procedure. So I think a good starting point. One thing I put in my syllabus was assigning Chris Walker and Scott McGadwin's Interpreting the Administrative Procedure Act, a literature review, which is a really good overview of the differing approaches to interpreting the APA, kind of textually constrained pragmatism, administrative law, common law, APA textualism, APA originalism. It's a really good kind of conceptual overview of the possibilities. And I think there's a lot that we could do throughout the course on that theme to kind of have line through the semester. Obviously, it's something that the court cares a lot about, and at least rhetorically is making nods to. So I think it's definitely something to say more about. I think the court's also sent mixed signals about how seriously it wants to take text and original understanding about various administrative law doctrines. So it's also an opportunity for us to highlight, where there might be inconsistencies in how the court is treating some of these questions in administrative law. Another big theme that I want to try to emphasize a little bit more, and I think I've already hinted at this as well, is that a lot of the recent developments in administrative law push in the direction of thinking more about how Congress can work in this new environment. So kind of hitting on some themes that Sabeel raised earlier. Some students, like some scholars, might think that the work is done here, that it was, Chevron that was enabling an inert Congress, and now that the doctrine's changed, so too should congressional behavior. Personally, I'm skeptical that Congress is ever going to adjust so easily to these signals that are being sent by the court. So, I think, there's a lot to unpack there about our assumptions about how administrative law doctrine might be shaping the behavior of other institutions, since that's such a core theory behind why the court thinks this is normatively attractive to make all of these changes. Now, that's not to say that Congress can't respond. And I think a big part of administrative law classes going forward should be thinking about what needs to happen at an institutional level for Congress to live up to the expectations that courts are now imposing on it. In other words, the course shouldn't just be about litigation. It should be about legislation and the legislative process, at least to some degree. Admittedly, that raises some questions about what's the boundary between this course, administrative law, and legislation and regulation, to the extent that you're at an institution that teaches both of them. Maybe there is, kind of a merger that's happening between those two things. But I think it's definitely something that you can use as a through line through the course. Because this is, at least in my reading of a lot of these cases, a real preoccupation of the court is at least a purported desire to try to light a fire under Congress. And if we're taking that seriously, it's worth thinking about what would need to happen in order for that to happen.
Can I jump in, Christine, with a quick follow-up question, which is to Dan? So the APA interpretation idea is a really good one. Would you or do you assign it with the other statutory interpretation materials as, because that is one way to do it, or when you're introing the APA? Because you could you could do it either way.
Yeah, I actually do it right at the beginning of the class, kind of in the introductory unit. That's, I guess, maybe an indicator of how seriously I am taking this this framing. I think you could easily just put it as part of the statutory interpretation unit, maybe along with Chevron, when you're teaching kind of the basics of statutory interpretation. But, it cuts across so many different domains of administrative law. Like I mentioned, informal rulemaking is really ripe for consideration about what is the original understanding of the APA. And so, depending on how you're sequencing things, it might be too late in the course if you're waiting to when you teach statutory interpretation as part of the Loper Bright unit. So I think there's a good case to be made for putting it right front and center, right at the beginning of the semester, and saying, look, this is going to come up again and again and again. Keep an eye on what the court is doing, how it's reasoning, whether it is very self-consciously trying to engage in administrative law, common law, and instantiate some values that we all have in administrative law, or is it trying to make some claim about fixed meaning? And then we can interrogate those claims. I think just having those framings in their minds at the very beginning of the semester makes them more attuned to see where some of these fault lines are.
That's great. Actually, that's one more follow-up question, which is the article, the plug of that article also made me think about something else. I'm curious what other panelists are thinking and kind of doing here, which is most of our conversation so far has been about Supreme Court cases and obviously like themes as well. But in terms of how much I every year think about and make some incremental progress toward, but never enough, assigning, non-Supreme Court opinions, non-judicial opinions, more agency materials, more guidance documents, more actual agency opinions. Like one year taught FCC versus Fox and actually had students read the underlying decisions. They're very long, but like parts of them that reflect the change in positions. And so I feel like that's always really valuable. But again, there's just a space challenge. So I don't know if others have ideas about new non-judicial opinions. I'm sorry, Christine, I don't want to hijack, but I can't, I can't help asking since we have these folks assembled.
No, I think that's great. And go ahead. I have some thoughts, but welcome others to take a stab at this as well.
Just quickly, I like this idea a lot, and obviously it's like space is such a premium. But I think one thing I'm thinking about doing this time is when I mentioned the case studies idea. This is partly why I'm interested in this. So for example, in a previous era, I spent a whole class on net neutrality, and where we read a couple, starting from FCC Fox through, I had to reread, skim FCC Fox, and then walk through some of the net neutrality cases. But in between, also it provided some excerpts from lower court opinions and like documents, materials from the FCC, from advocates, in those early days to sort of give a sense of that back and forth of roads not taken. And I think a lot of these issues are really ripe for that kind of treatment, this time around too. I haven't decided yet which ones I'll zero in on, but like with major questions, the student debt case, there's so much richness there about like the agency's document interpreting the HEROES Act in the first place, leading up to Biden v. Nebraska as just an example. And sort of your point earlier about the Fifth Circuit decisions. I do kind of want to just, for pet interest, I want to get some Fifth Circuit opinions in there this year, just because I don't think you can understand what's happening in the country without understanding the Fifth Circuit. But we'll see how much I can squeeze in.
Just really quickly responding to Kate's question about, primary materials and the like. I think one device that always was really useful for me for just kind of showing students what happens inside agencies was this old documentary called The Regulators. And it's now quite dated. It's still up on, I think, C-SPAN's website. So I actually assign it and have students watch it. And we would talk about it in class, and sometimes I would supplement it with some of the primary documents. Josh Galperin actually gave me that idea. He has assembled a bunch of the primary documents from the real rule that the Regulators is talking about. But it's quite dated now. So one suggestion for somebody out there, I don't know if we have any filmmakers in the audience, but it would be great if somebody made a new documentary about the regulatory process to kind of substitute for that old documentary.
All right, thank you. Oh, go ahead.
No, I just want to say I'm not a filmmaker at all, but I want to go back to something that a through theme that I think has underlined much of what you all have said, but you haven't quite hit it, which is really there's just a basic separation of powers issues that come to the fore here. I mean, what the court is saying is Congress doesn't have the right to protect officers from removal. Congress doesn't have a right to vest these issues in adjudication. And maybe even Loper has some separation of powers overturns too. So that's another theme. And I don't shy from that theme at all, but I think it's important to show that the court is not just anti-agency, it's really cutting back Congress's powers. And that's something that's very significant with this court. And I think you probably all agree with me, but I just wanted to point that out to everybody in the audience too.
All right, thank you. And I would just add quickly that I too have used FCC versus Fox, the agency record in the fleeting expletive case. And I use an excerpt and I use that to introduce standards of review, because if you look at that initial agency opinion, there are questions of fact. There are about who said what Paris Hilton said. There are mixed questions of law and fact, and there are a number of different questions of law. So there's a constitutional question, there are questions of procedural law, and then there are questions of substantive law. And I use those, or when there's still Chevron deference, I guess I use those to kind of set up the idea that there are a number of questions of law. For a lot of those, the standard of review is de novo. And maybe it's all of those, but just to give students a real world example of you're going to have a messy opinion and there'll be a lot of different issues where you can pick out different potential questions with potentially different standards of review. And I find that helpful in setting up the idea of, what kind of deference we're going to have under these different standards for questions of fact or mixed questions, policy questions, or questions of law as well. So.
Well, one thing that I wanted to ask that came out of the very first chat question actually is, and this relates to this question of things that we might bring into the classroom other than Supreme Court decisions. Someone was asking if there's good or what you would point to as good empirical work on, sort of the impact of overruling Chevron. So in other words, how big of a deal was Chevron in terms of helping agencies win before, and the work that's been done on that? How big of a impact can we, or how big of a change can we expect after Loper Bright? What kind of empirical work people might be doing now to kind of show the impact of Loper Bright? And that sort of makes me think about maybe a broader question just about, the extent to which you might bring academic literature, law review articles, either empirical or normative or historical, kind of into the classroom.
You want to take a bite at that question?
Well, I guess I'll say a little bit about the empirical side of things. I mean, I think it's always difficult to bring in empirical evidence in the classroom. At least it's been my experience. You can certainly, highlight high-level things and the like, but you don't want to get too bogged down in the methodological details of things. And unfortunately, with this particular area, the changes are going to take a while before we can reliably assess them to see how big they are. I actually have a draft of an essay with Carrie Colonisi right now that we haven't posted yet, that makes pretty much this point that, although there's a lot of prognostication right now about how, the decision will have this huge impact or maybe no impact at all. And really, we see scholars and commentators all over the map. It's just going to take some time to really know what the impact will be. Certainly, there's been an unsettling of an equilibrium here. But it's not out of the realm of possibility that a new equilibrium will pretty quickly establish itself, and that it might not be that different from where we were before. So, really reliably assessing the impact of Loper Bright, we can't expect to do it for, years, maybe even decades. Even Chevron itself, it was pretty difficult to tell whether it made any difference, right? Very little empirical evidence on that point. So yeah, I mean, I think it's going to be a question that students ask, right? Or interested in, how big of an impact this is going to have. And I'm very tempted, just like a lot of other people, to want to turn to empirical evidence for an answer to that question. But I think it's going to be very difficult in the short run to have a convincing answer on that front.
Well, I'll also add, in terms of just adding scholarship in general, I sometimes like to add, just very briefly for my class, some points on some of the originalist debates over non-delegation or the unitary executive. That's an area of my scholarship, but just to flag for students, some of these arguments, or maybe the reasons the court might be departing from the doctrine we currently have, are somewhat new, or maybe what's old is new if you're looking to originalism, to say now that parts of the administrative state we've had for a long time are being challenged on the grounds that they are no longer viewed as consistent with original understandings. There's originalist debate over that contested point, but it's always a challenge, because if you want to go to a deep dive on those questions, there's not really enough time in your course. But I found it effective to have maybe just a couple of slides saying, here are some articles of scholars who have competing views on whether a strong non-delegation doctrine is consistent with the original meaning of the Constitution, and just put those up for students, and happy to engage with them in further questions after class as well. But that's a way to, I guess, plant the seeds of some of those ideas without getting bogged down in, I think a lot of these historical and empirical questions are fascinating topics of research, but ones that are very difficult to introduce in the confines of a 3-credit course that most of us have. All right, and if no different additional questions or points on this, also curious to get some of the panelists' take, and maybe I'll start with Sabeel for this one, because I think you alluded to this before, but we've all been talking about how quickly there has been change in administrative law doctrine, these major areas, getting rid of Chevron deference, et cetera. And so it's similar maybe to something that's happened in constitutional law, where we see maybe sudden political change, or change that's associated with a change in the court's membership. And maybe that's challenging to explain to students, as a lot of what we teach as law professors is doctrine. And in some of these cases, there's not a neat doctrinal story that we can tell. I think Jarkesy is an illustration of that, and there may be others. So I just wanted to get your thoughts on how you talk to students maybe about that kind of legal realism or judicial politics aspect of what may be happening in some of these cases that doesn't fall neatly into a standard doctrinal explanation. And Sabeel, since you alluded to this before, interested to hear some more of your thoughts.
Yeah, great. Now, and I think this has come up already from a bunch of different angles from the panelists. I think in some ways, I'm going to be, my plan is to be a little bit more con law-like in my admin law class, or not a little bit, a lot more, in that I often start my con law class from the get-go, being very explicit that we're operating at multiple levels in con law. And I think it's true in admin law. It was always true, but I think it's especially true now, that there is sort of an internal doctrinal level, which is like, what are you going to actually put in a brief, or if you're like operating as an advocate, what can you say? And you need to be able to try to wrestle with the doctrine and make sense of it, even if it doesn't make sense objectively, because you got to put something on paper, and that's one brain that we're using. But at the same time, simultaneously, to have it sort of outside of the doctrine lens, which is there's a broader normative, political, ideological, historical fight going on. And that's not to say that, you know, there aren't sort of good faith sort of postures on that have multiple different views on what the right scope and scope of agency authority is. But I like to sort of set that up and name it right at the very beginning. And then it becomes something you can kind of go back to as things go through. You know, someone asks like, well, what's a major question? How would you know? I don't know, actually. I can give an argument, but I also think there's a realist explanation for what is major and when something is major. And so I want to set that up at the beginning. But I think it's important to sort of try to do that in a way that also still like creates the container for a more doctrinal focused part of like large chunks of the class, and just being explicit to the students that, you know, right now we are using the brain of like, what can you argue in a courtroom or put on paper in a brief, which is a different brain from what do you as a human in the world think about this? Is this totally dumb and stupid an opinion? It might be. You're allowed to think that, and we should talk about that. But I like to separate those postures.
All right, thank you. Would anyone else, and I think since we're kind of running a bit low on time, I won't go through the entire panel, but anyone else who would like to weigh in on this question?
I'll weigh in. First of all, I just want to say I completely agree with Sabeel, and I love that framing of two different brains. I'm gonna steal that for sure. So on this question, I think it's fine for students to be a little disillusioned about what they're seeing, especially given how quickly things changed once a few key justices came out onto the court. And how little the court has done to calm the nerves of those who see the same justices eyeing bigger prizes like Humphrey's executor. So, I wouldn't fight that too much. I think they're reasonable to be disillusioned about it. But I guess I would try to tell them that it never was very realistic or even very constructive to think of administrative law as inoculated against politics. The entire field, if you look at it historically, grew up as part of a political project, a positive political project of modernizing government and strengthening democracy. And those are not neutral values. Those are political commitments. And what we're seeing now is part of the ebb and flow of the politics of the administrative state, a pushback against that. And I think there's going to be further chapters in this long saga. So rather than focusing on procedural legitimacy of the changes or, how, little regard the justices seem to have for stare decisis, which, there's a place for that discussion. I think what we should say is for those who have a different vision for what administrative law should look like, or who think that these are problematic decisions, how they can make that happen. So in other words, I would try to change the valence of the claim that this area of the law is politicized. It is, but I think that's actually probably a good thing because it means that the future is very much in our hands.
All right, thank you.
And I'll just say, I give a very similar spiel to the one that Sabeel just described, but I sort of talk about it as like just kind of operating in two different registers, right? Like the internal logic of the doctrine, and then, sort of a kind of at a remove sort of critical assessment of what we actually think is driving the justices, but we're obviously not going to make arguments in that second register if we're practicing before agencies or if we're agency lawyers. And so I think that if the class is successful, there will be some, kind of ability to reason in both different registers by the end of it. And I think I also really liked that Dan sort of a reminder that, that there was a deeply and differently kind of political component to administrative law from its inception. And so that's a good sort of reminder as well.
All right, thank you. Any final thoughts? These are all great ideas, because it's always something I wonder about or struggle with in class, to have the two brains or two different registers, and just the idea that this is an area where there's a long political history are all very helpful. It looks like in the queue, Glenn, maybe we have a lot of questions. Is this a good time to turn it over to questions from the audience so people have a chance to raise some additional points?
Yeah, sure. And a lot of the points or observations that have been made by the panel have been already responsive to a number of the questions that have been asked. One kind of more doctrinal question that I think is interesting in terms of thinking about teaching has to do with the connection between the non-delegation doctrine. And I, this came up in a discussion, Sabine, for example, you were saying how the different issues come up at different points in the class, and you have to kind of revert back to things and talk about things in multiple contexts. But like, the relationship between the non-delegation doctrine and the statutory interpretation issues, particularly with the major questions doctrine and post Loper Bright, how do you plan to explain that connection or teach those issues to the students? Did anyone have any thoughts about that?
Maybe just quickly, I think I alluded to this earlier. I think my current thinking is to sort of put in one unit sort of arc of non-delegation cases, and then moving into Chevron and Loper, and also major questions, because there's sort of like a kind of common sort of intellectual battle in all of those different areas, and then that kind of can set up. I'm hoping to do that early in the semester, maybe even right after some introductory unit, just to kind of set the stage for then everything else that follows. Because in some ways you could argue every other doctrinal sort of like jousting is a transposition of those original of those same concerns, right? Do you dial up arbitrary and capricious scrutiny? Well, in part it's because you're worried about arbitrary agency power. And in some ways very similar to the non-delegation sort of core normative question.
I don't think it matters that much. I take a slightly different tack. I talk in the introductory class or two about why people are skeptical of agency power. Why might they like agency power? And that depends upon your priors, your norms, your views. And so I say that you can't understand the arc of administrative law doctrine unless you understand these priors. And so then it will come up. And so I don't put Chevron and non-delegation back to back, but I say it's the same kind of concerns that manifest themselves in one, manifest themselves in the other, and it's both tied back to the introductory discussion of why you might be skeptical of administrative power or not, bureaucracy, unelected, all those kinds of things.
And if I understand like at least one aspect of the question, I presume it's referring to the part of Loper Bright that says, well, if there's, and this is back to sort of Dan's question about an explicit sort of delegation of authority, how does this square? If the court says actually there may be some explicit delegations that are permissible, and that is the delegation of a degree of discretion on the part of the agency, does that necessarily mean Congress has not provided an intelligible principle that would satisfy the sort of classic non-delegation doctrine? So actually the kind of it's like a null set, like the category of things that Loper Bright says actually might be permissible kinds of delegations would run into the kind of buzzsaw of the kind of limits of delegation. Maybe the point is that Congress like actually can't give agencies the power to do anything ever. And I think that is a totally reasonable way to understand how to reconcile the two. I mean, presumably the court does mean in Loper Bright to allow Congress to do some things in the way of empowering agencies to exercise discretion, but maybe this is where, and maybe again, Dan's drafting exercise idea, which I also quite liked, would reveal that anything, that would work on Loper Bright would be problematic under the non-delegation doctrine. I don't know if others have thoughts on this, but I think it's a totally fair tension to identify.
Yeah, that's a great point, Kate. And I think that was actually like the thrust of the question, is that there seems to be a lot of tension there. One of the other questions has to do with the impact of the changes within the Supreme Court on the lower courts. And whether they're sort of up for the new responsibilities that seem to be imposed on them. And, I guess I was thinking about this in the context of the bucket where we're teaching students how to be advocates. Some of that advocacy is going to be in lower courts. So, what does that look like, and how do we talk about it as teachers? Any thoughts? And I think there's a related question maybe is, how thinking about this from the perspective of agency officials themselves, right? How gun shy are they going to be, to do big things now, or even, to expand the scope of their authority? And is that something you bring into the classroom as well?
Yeah, so I'll say a little bit about this. I think one thing I wanted to mention earlier, actually, about the question of other things to bring into the administrative law curriculum that I forgot to mention was, kind of the lower courts and the specific question of remedies and injunctions, universal injunctions and the like. And so I think, I've already gotten some questions about it. I started teaching this week, and students are chomping at the bit to get some answers to questions about what happens when you have conflicting injunctions and the like, which seems to happen now. I think that you can't avoid that topic, and it is an opportunity maybe to raise some of these questions about how some of these doctrinal changes coming from the Supreme Court will play out on the ground level in the lower courts. Like if you have a remedies section, even if it's short, you could start to raise some of these questions about whether lower courts have enough capacity to really do this, whether they can coordinate with other circuits to do this in a way that won't completely derail government, et cetera. So maybe that's the right vehicle or vessel for that kind of discussion. And I would just say substantively on, what might be helpful. I mean, I'm contradicting myself a little bit because I said earlier I try to avoid putting empirical stuff in my class, but there's a fair amount of political science work on the relationship between, higher level courts and lower courts. I mean, the judiciary is a very complicated institution, and there certainly is a lot of evidence and a lot of theorizing that happens in political science about what that relationship is, how the Supreme Court keeps tabs on the lower courts, what kind of capacity the Supreme Court has to make sure that its rulings are being followed faithfully by the lower courts. So maybe some excerpts of that literature would be helpful for just conceptualizing the challenge that the lower courts have in front of them.
No,
go ahead, Kate.
No, please.
Okay, well,
no, you talk about courts, and I'm going to talk about
quickly.
agencies.
Yeah, I'll bridge you to agencies then really quick. So that's really helpful what Dan said. I was also sort of flirting with, I don't know where I would put it, a little bit of like a short primer, maybe it's a few minutes of lecture on like injunctions, shadow docket, like all these other things that like kind of are more in the headlines and less in the sort of like standard kind of admin 101 structure. Just on the agencies point, in part just because given my own sort of experience here, I do want to try to put some more time in there. In part, just talk a little bit more about like the sociology of agencies, right? I mean, of course, some great material on the internal administrative law and so on. But this question of chilling effect or not, but also this question of bureaucratic capacity. Like it's really hard to write these rules or to sort of implement these policies, and people work really hard to do them, even if they don't get it right all the time. And I do want to bring that like human aspect to it, because a lot of times both Congress and courts are even when they're supportive of agencies, have these kind of like superhuman or abstract kind of theoretical notions of, oh, the agency can just do X instead of Y, and it's not that straightforward. And so I do think there's some color that I want to bring in some form.
Well, and you certainly have the personal experience to do that for your students. I was going to say, I don't actually know how, apart from obviously we can sort of all draw from our own experiences. I was just going to reference something that I did an ACUS panel with about Ohio versus EPA a week or two ago. And I sort of asked this question, like, so how should agency officials understand their like task of responding to public comments when they're involved in a rulemaking differently as a result? What should they do differently? And Nick Bagley said something I thought was really great, which he was just like, nothing. You should do nothing differently, because it's Ohio versus EPA just does feel like, ironically, the ultimately kind of like arbitrary and capricious exercise of power. And if you are going to nitpick to that extent, it is, you cannot judicial review proof any kind of rulemaking process or output. And thus, especially if you're the EPA, maybe like definitely for the EPA, but other agencies are vulnerable as well. You simply have to, you have statutory directives, you have both authority and obligation much of the time to engage in various kinds of processes. And many of the kind of like, whack-a-mole decisions of this Supreme Court make it almost impossible to respond in a rational way. And thus, like, agency officials should not let themselves be hamstrung by some of these directives. Again, I don't know exactly how that cashes out pedagogically, but I thought it was actually a really good and important point. And so I thought our audience might benefit from hearing it too.
Yeah, just quickly, I love that, Kate, and I think it brings up for me something that Hal said earlier in this conversation about how really understanding these as much an attack on Congress as they are, these recent decisions, as they are an attack on the executive branch agencies. Because in part, like, there's a very low upper bound to how much you can sort of strategize your way through this new thicket. And the implication for me is that, well, the Congress has to get in the game. And so I tend not to spend that much time on Congress in my admin law class, but this conversation is especially making me think, some way to sort of bring that in more. I know, Dan, you gave some great suggestions, but something for the students to also start to think as lawyers and potential problem solvers, practicing in this area for the future decades. You might actually, if you're an administrative law, like fan of this topic, maybe you should actually go work in Congress, right? And not in the executive branch, because we're going to need more admin law people, staffing up Congress to help navigate this stuff.
So there was also a pretty discrete question in the Q&A or the chat about what you all think the significance of Gorsuch's Loper Bright concurrence might be on stare decisis, and whether maybe that's something you would plan to discuss or focus on at all in class. And maybe, this also ties to, the bigger question about the court's respect or lack thereof for stare decisis more generally, and some of these, issues about the political nature of the current court's work. So maybe the broader question to address is, to what extent do you discuss stare decisis in administrative law, and how does that connect to things? And is Gorsuch's concurrence a big deal worth discussing? Anyone? You're going to make me cold call. I feel like I'm in class. Mr. Walters.
Yeah. So I actually didn't assign it, and I don't plan to discuss it. To be frank, I'm not interested in the conversation about stare decisis, because it's so clear that the court doesn't care about it. They overturned Roe v. Wade. I don't see much value in having that conversation, at least in this class. In a jurisprudence class, sure, but in administrative law, the writing is on the wall. This court is willing to do anything, I think. I suppose there might be some value in, trying to highlight some of the inconsistencies and, the poorly worked out theory of stare decisis in the Gorsuch concurrence. But to me, that's just, kind of fiddling while Rome burns, so to speak.
Okay, well, this question, I'll read it directly, and you might have a similar answer, right? But it says, building on what Sabila has said, I've heard someone say, only partly in jest, that the court may be moving toward a Bruin-like endpoint in administrative law. Does anyone think that a return to some real or imagined pre-New Deal version of administrative law is possible? I don't know, I guess it's a little bit about where we think this is ultimately going and what that might look like, and the extent to which we might, have that discussion in class.
I don't think the court's going back in terms of like Bruin, in terms of some kind of tradition, and what the rights are in terms of limitations on gun ownership. But they certainly are moving to some kind of error that we don't know where they are. They can't turn back the clock. There were administrative agencies at the time of the framing, as you all know from looking at the history, but at least something would be classified as administrative agencies today. But the court's paring it back. And so I think we all probably agree, with differences maybe that are minor, is to see where the court is paring it back. And I think we should tell the students why the court is paring back powers of agencies, and then highlight doctrinally what are the soft points where that may happen. And, if they're representing some kind of companies, whether it's Starbucks or whether it's Tesla, they can use these doctrines to push back and help their clients because we can help them by predicting where the lines of weakness are from the court's perspective today. But I don't think it's going to be back to that kind of doctrinal shift.
I mean, maybe I'll just jump in with one thing. I mean, there is definitely something very Bruin-esque about aspects of the court's major questions cases, in that like the novelty of a regulation is one of the strikes against it in the major questions assessment. And it is just the least textualist possible method to determine the permissibility of a regulation or of an agency action under a particularly like an asserted statutory authority, like how agencies have previously acted pursuant to that same or similar authorities. It's just so hard for me to understand how these avowed textualist justices could possibly think that that matters. And that is very Bruin-like, right? Like, is there, in the constitutional analysis, is that, is there a regulation that looks like this regulation? And, in the view of a majority of the justices. So I do think that there is an interesting parallel, at least in the doctrine there and maybe elsewhere.
Do you think that's going to survive, Loper?
The major questions doctrine? Or you're saying the aspect looking at previous exercises of regulatory authority?
Yep.
Yeah, I mean, I do.
I'm not sure.
Okay, well, when you say
I'm curious what other people think, right? Because if you're looking, well, just as a statutory interpretation matter, the question should be what the court thinks the statute says. And as you point out, what's happened in the past really may not be relevant to what the statute understood says. So it could happen, but I'm not convinced that the court will maintain it. That's all.
That aspect of it. I mean, but the problem is, like, it would have to throw out the entire major questions doctrine, because almost none of it has to do with it. There's both the kind of the history of agency practice under the statute, the kind of novelty issue. There's also the the sort of political and economic salience or significance that's also completely unmoored from the text of the statute. So I mean, unless it's willing to say this doctrine that we have really, done enormous work with in recent years, like, oops, I actually don't know how they could possibly justify repudiating it. I suppose they could stop deploying it if they think they can invalidate agency action that they're hostile to under, just like a pure statutory interpretation approach. But I'm just not sure. I mean, much of the time, it's this kind of first order authority to act as opposed to the specific meaning of this. But that's, that traces back to the words of the statute too. So you're totally right that there's a lot of tension between the two, but I have a hard time sort of seeing them jettison the doctrine after sort of just having fashioned it out of clay.
If I may, I would also just like to add that under Skidmore, there's an idea of consistency in agency interpretation as well. And I mean, getting rid of Chevron deference, where the point there was agency interpretations are not carved in stone, but now Skidmore is still preserved. I think there's probably, something to that strand of wanting to have some kind of precedent, right, for what the agency has done in the past, perhaps under Skidmore as well. And we're going to be leery and suspicious if there's a new interpretation that hasn't tracked how the agency has handled that statute or that situation before.
Yeah, just a quick thing to add on this. I agree with the spirit of the question in terms of potentially sort of wide-ranging implications, sort of Bruin-like. But I guess something I'm toying with is I don't think it's quite right to say that where the doctrine is going is taking us back to the New Deal, because it's deregulatory in some ways and actually weaponizing or unshackling state authorities in other ways that are really problematic. And so, insofar as Project 2025 might feature into my syllabus, I haven't decided yet, but I think that's one of the lessons of Project 2025. And even in this last few years of court decisions, right? I think you see with this court, they have been sort of paring back agency authorities in some domains and actually giving wide berth in other domains, immigration, say, or the surveillance state, or and so on. And so one thing I'm thinking about is I want to bring more of the second bucket of cases in than I might have previously done, just to illustrate that we are not actually in a big versus small government fight. Even though I myself often default to that, I just don't think that's really what's going on. And so I want to try to bring that in some more.
So there's one very discrete question about talking about these statutory interpretation issues and how much importance that's going to have going forward. If there are like good primers that you all sort of have or recommend for students to just get a grasp on the basics, like if you don't want to spend your whole semester teaching legislation in administrative law. So this is your chance to get to endorse your friend's work or something, or your own work.
So I'll jump in here. I've always really liked this short book by the late Judge Robert Katzman. I think it's called Reading Statutes. It's very accessible. It is very short, and it walks through cases in a really kind of intuitive way. What I really like about it, though, is it also highlights the kind of legislative capacity angle that I was talking about earlier, like what we can do to improve drafting in Congress in response to how courts interpret statutes. So I think it's just all around like a really good short primer on statutory interpretation. It's not going to cover every doctrinal nuance, but you don't need that really for this class. I think this is about all you need.
Great. Well, thank you all for answering these questions and for also anticipating the answers to a lot of what was in there as well, because you really did cover much of the field. So appreciate it.
All right, and I think we're about at time unless anyone has any kind of final remarks, but thank you all so much. I feel like I've learned so much from hearing your thoughts on how you'll shape your course or what you have been doing in your course. And just as a reminder, we do plan to post this, the AALS will post a recording of this, because I certainly know I want to come back and think more about some of the comments all of you have made. And also do keep in mind that we have on our website a syllabus and eventually exam bank. So to the extent you're putting some of these ideas into the syllabi that you're crafting for this semester or next semester, please do post your work there so you can share with others and people can take a look at maybe how some of these ideas have been implemented or just get ideas for how they would like to structure their own courses. And with that, thank you all so much, and hope it's a good semester for everyone.
Thank you so much.